Hi, everyone. Welcome to our webinar. Let's wait a few more minutes just to let some people join. But in the meantime, I'd love to introduce Darrow. We are an AI research lab for those of you that don't know us. My name is Jake Hirsch. I am Legal Intelligence Quality Counsel here at Darrow. My job, in short, is to take the cases that we research and explore and to verify that they are strong from a merits perspective and viable in the U.S. legal system as a U.S. trained lawyer. I have the distinct pleasure of being joined by my esteemed colleague Shai Silverman here today. Shai, thank you so much for joining us. Would you give our audience a brief introduction as to who you are and what you do for Darrow?
Sure. Thank you, Jake. It's a pleasure being here. I've been at Darrow for the past 2 years. I've worked mostly with ERISA in defined contribution, in defined benefit, and on ESOP cases. I've also worked a bit on securities. And my job here at Darrow is using AI and data mining tools to identify those legal violations.
Amazing. Thank you, Shai. Once again, thank you for being with us. And I think we're just about ready to begin. So once again, welcome to all of our guests here today. We will be discussing on this webinar employee stock ownership plans, otherwise known as ESOPs, and the litigation trends surrounding those types of plans in the context, of course, of ERISA. Shai, before we get too into the nitty gritty, would you mind just giving sort of a high level overview of what an ESOP is and the more general context of how these litigations tend to arise in practice?
Sure. So ESOP plans were created by the federal government in order to incentivize greater participation of employees in companies, mostly medium-sized private companies. The idea was that if they felt they had a stake, if they felt they had a financial incentive to dedicate themselves in making sure that the company grows with them, everyone essentially would be benefited. So ESOP plans work in a way in which participants, meaning employees, get a percentage of shares from the company, either 100%, either the company is entirely owned by employees, or a percentage, 30%, 50%. And once retirees have worked for sufficient time, they are vested, meaning shares are allocated, and then they can either sell them or keep them as investment. So theoretically, those plans were created as a good thing, as a way to incentivize the economy. What we've seen, however, is that in some outlier cases, the whole idea is circumvented in order to benefit fiduciaries and/or plan sponsors, sometimes also third-party trustees that end up harming participants instead of actually benefiting them.
So I think we've all kind of heard in the media or, in press releases, you'll hear the sort of term employee owned in the context of a company. So this is that, essentially. This is one of the mechanisms that a private company, predominantly, as you mentioned, could transfer its ownership interest to the workforce and then claim that sort of employee owned status. As you mentioned, it doesn't always play out in the fairest, most above board way, but that's the general idea from like kind of a general factual perspective. I just want to give the legal context a bit. Generally speaking, in ERISA, fiduciaries are prohibited from engaging in transactions where they have the plan purchase or enter into transactions with the employer or the employer's sort of interests. That's just generally prohibited under ERISA. It's known, unsurprisingly, as a prohibited transaction. But in the ESOP context, ERISA actually carves out an exception to that prohibited transaction rule, where it says essentially you can engage in that self-interested transaction if it is done with adequate consideration. Essentially, if the transfer from the employer to the employees reflects an actual fair market valuation of the value of the company. So that's a little bit of the sort of legal background. Shai, can you talk to us about sort of like how these litigations play out in practice? Um, are they long? Do they settle? Any details around that that you could give us, I think, would just help set the stage a little bit of what we're talking about here.
Yeah, so like you said, transactions like these have to have adequate consideration from fiduciaries to respect the best interest of participants. Here, fiduciaries sometimes act as both sides of the transaction. They both sell the company and they have to step into employees' shoes to make sure that the transaction is fair enough for participants. And what this litigations claim is that prices are inflated, meaning that companies are over-evaluated in order for participants to have to pay more money to take ownership of the company, either full ownership or partial ownership. In many cases, these fiduciaries will hire third-party evaluators that don't necessarily act independently because of financial incentives. They might only get paid if the transaction is completed, or they might only get paid if the transaction reaches a certain percentage, which means that, to answer your question, the incentives here are very, very high for fiduciaries to act on their own behalf rather than on that of employees, which means that usually the price drops that actually come to being litigated are so steep, are so egregious that most of these cases, around 80%, according to extensive research we've done, tend to settle. And that's because the violation is out there. It's because it's clear to a judge or to whoever looks at either the Form 5500 or internal evaluation documents that the price was inflated. You can't have a company that in 2022 was worth allegedly 250 million and 2 years later was worth 10 million, which is something we've seen in quite a lot of these cases. Essentially, it means that there were reasons, there were metrics that fiduciaries either known or should have known at the time of the sale that mean that the price evaluation wasn't fair. What's encouraging for plaintiff law firms that work in this area is that these cases tend to settle, like I said, and tend to settle fast. Very unusually, they get past discovery because, like I said, the violation is quite self-evident. It's very hard for fiduciaries to be able to claim that the transaction was conducted fairly when you see the discrepancy in what participants are paying for and what they got in the end.
Super interesting. And you mentioned that significant price drop that, in my experience at least, I've seen can happen quite quickly and precipitously after the transaction is actually consummated. Um, I think a lot of people might be wondering, and I'd be curious to hear what you have to say about it. How do these employees even pay for that initial amount of money, that the inflated value? My understanding is that it's actually debt that's issued to them, essentially a loan from the company that bears interest for an extended period of time. So it's actually the employees incurring debt for the privilege of owning a company that they're paying too much for. Is that an exaggeration? Can you speak a little bit more to that sort of leverage dynamic at play here?
Yeah, by all means. So the element of time is something that really catches the eye of anyone who reads one of these documents because leverage transactions means that either the company or a third party, a bank or a financial institution, will loan the ESOP, the participants, the liquidity to buy the shares at that particular moment. An ESOP is almost never going to have hundreds of millions of dollars in cash to buy the company at any given moment, so they'll need to borrow it from someone, and those loans tend to be very long term. Usually they are between 30 and 45 years, but we've seen cases in which participants are settled with debt for 90 years. And
Wow.
usually those companies tend to drop in price very quickly. So you have a loan to be paid over 90 years, which accounting for interest and inflation will be likely around 200 or 250% of what of the cash that was loaned in the first place. And on the other hand, the asset you bought with that loan is essentially worthless. Many of these companies even go bankrupt before the loan is paid off. So you can see that there's a significant discrepancy in both the time and the amount that the participants actually get in compensation for taking a loan for such a long term.
Wow. I mean, Shai, forgive me. We'll have to invite people back for our next defined benefits webinar to discuss whether or not it's reasonable to assume that people will live for 90 years to be able to pay back that debt. But I think everyone listening can agree that's quite a long time to be saddled with debt for something that may end up actually having no material value. That's pretty staggering stuff. Can you, just taking a step back for a second, can you give us a sense of how does Darrow find these cases? What do you look for? What kind of pools of cases, like what are we talking about here?
Yeah, so in order to identify those cases, Darrow uses several different data mining and AI methodologies in order to sift through hundreds of thousands of filings, public databases, Department of Labor databases, whatever we can gather online in order to identify ESOP transactions that happened within the last 6 years, which in this case is the statute of limitations. And by using those elements, we're able to identify those in which there was the most significant drop in price between the moment of sale and the most recent available evaluation. We always also look for additional elements that might strengthen the narrative of self-dealing. We'll give a few examples in a while, but these are plentiful in ESOP cases because, like I have been saying, the incentives are very, very high, and we've seen some egregious situations. Now, I just mentioned the statute of limitations, and that's something I want to approach because I've seen also cases that Darrow's tools were able to identify in which a transaction that clearly harmed participants, meaning they had to pay for $100 million and they now have $10 million in assets, has already passed the statute of limitations, meaning transactions that happened in 2019 or 2018. And unfortunately, now, because no one was able to get to them before Darrow did, those participants are saddled with the debt, and there isn't really anything they can do. So, apart from us being able to identify those cases, from a business perspective, there's also obviously the social impact because we are able to prevent that other plans reach a situation like that in which they are stuck with debt for such a long time. Money doesn't come for free, and ESOPs are only one part of retirement available to employees, which essentially means that if they are still employed at the company, they essentially have to take off their 401k or off their savings or their pension, whatever it is, in order to pay for this flawed ESOP. So what we're doing here has the potential of ensuring that this won't happen anymore. From now on, whenever a transaction like that happens, Darrow will flag them, will do its best to bring it to justice to make sure that those participants are not harmed in any way.
Yeah, I mean, just from a quick legal perspective here, I would imagine, given sort of and maybe we'll touch on this a little bit later, but sort of the limited amount of information about valuation specifically, company valuation pre or immediately post ESOP transaction that's disclosed in regulatory filings. I assume there's also a dearth of information provided to the employees themselves. There's an argument here for fraudulent concealment to maybe toll the statute of limitations period for, until the actual fraud was discovered, maybe allowing those really screwed over individuals to maybe approach the courts and try to make that argument to say that the cause of action hadn't yet accrued until they found out about it. But of course, I think maybe a lot of our guests are plaintiffs' firms, plaintiffs' lawyers, maybe not. But I think, that's just another hurdle. So I can imagine why sort of the baseline filtering and review process with the tools that you mentioned focuses on that core 6 year limitations period. But anyway, I really want to zero in on this social impact narrative element that you talked about. I know we've both, in our time looking into this cause of action, seen some really egregious, heartbreaking scenarios play out. Maybe we could both share a couple. I know that the way in which it's most easy to understand the extent of the harm that's going on here is to, and you've already kind of introduced us to this, but to understand the players in these transactions, make sure that you understand sort of who's the sponsor, who are the lenders that you mentioned before, who are the trustees, the auditors, the employees. So before we get into those narratives, let's just sort of level set on that. I think you would agree with me that sort of the sponsor is typically the employer, who also may be extending some of that lending to the employees to be able to sort of pay for the benefit of these interests in the company. You also have third-party lenders, as well as the appraisers who are actually valuing the company to set that purchase price. And then finally, I think you have sort of the trustees that, like theoretically at least, should be sticking up. They should be independent third parties sticking up for the interests of the purchasing employees and really the plan that's purchasing these interests. Anything to add there? Are those kind of the key players that you see? Anyone else I'm neglecting to mention?
No, that's absolutely right. I would highlight two parties. One is obviously the sponsor, which is the employer. But second is the trustee. Usually these plans tend to hire an outside trustee, which tends to be a respected financial institution in the field, in order, theoretically at least, to ensure that transactions are completed in a way that respects participants' interests. And that means the trustees also take upon themselves fiduciary duty, which, as we all know, is very relevant specifically in ERISA. And often the main named defendants in these cases are the trustees. So it's pretty clear that they have a responsibility to make sure that the evaluation is fair, and more often than not, or at least in the cases that we flagged, they don't. We've seen that the evaluations were so egregious that a professional financial institution would unlikely have missed it, which makes them one of the essential parts of this case, also for collectability purposes. Often these the sponsors themselves, the previous shareholders, are family members that used to own a company, that started a family company and then wanted a way to get rid of it. They wanted an exit. So you might have some collectability issues with those individuals, but the trustee is usually the most guaranteed way for lawsuits like this to be collectible. Now, in terms of the narratives we've seen, in terms of the elements we've seen that I would really call just horror stories, the kind of stuff that happens here is really scary. We've seen cases in which the sponsors simply changed the auditing firm. They changed the individuals responsible for evaluating the company because they weren't satisfied with the previous amount that was granted upon the company, so they replaced it in order to have a better appraisal. That's something that has been flagged in recently litigated lawsuits. And most of these ESOPs are essentially just family companies that were started 50 or sometimes even longer ago. And when the family patriarch passes away, the children or the grandchildren don't really know what to do with it or don't want to continue to run it, and try to get rid of it or try to exit in a way that would give them a significant amount of value. Many of those actually try to sell to investors. The first route instinctively tends to be investors, private equity, but many of them can't, because essentially investors have access to information that employees are deprived of. Investors, whenever they are looking into buying a company, they ask to look at financial reports, and they would likely flag whatever is the reason that's wrong with this particular company and would then not proceed to buy it. Employees, however, don't have access to that information, and even if they did, they wouldn't by themselves know how to interpret it. So family companies are a special pool of these types of ESOP litigations because of every incentive involved.
It's just super messed up. I mean, either way you look at it, whether it's, switching out an appraiser until you get a price that you like, or trying to sell your company anywhere in the market, realizing you're not going to get as much money than if you just screw over your own workforce. Like, it just reeks of culpability. And we've both seen these cases, but it does happen. It's hard to believe. I mean, I'm almost sort of tempted to ask you, obviously, at Darrow, being the research lab that we are, we're trying to find examples, out there where this has already happened. I'm almost tempted to ask you, like, from a policy perspective, how would you stop this from happening? That's maybe a better question for your local congressman or woman. But just curious your thoughts as to that. I mean, perhaps there should be sort of like a judicial proceeding or something where you bring another actual neutral third party in here to like ensure that these things don't happen again. I don't want to put you on the spot now, Shai, but curious to hear if you have any thoughts about that. And if not, that's totally fine.
No, absolutely. I think that, again, everything here is about financial incentives. If the current shareholders have such a strong incentive to just name a price and sell themselves for any given price that they can, and then just settle the ESOP with that loan for 90 years and then wait the 6 years of the statute of limitations to get rid of it. In some instances, that's what's going to happen. I can't really tell you what to do from a legislative perspective. What I can say is that Darrow and plaintiff law firms and other agents in this area are trying to make sure that these instances don't really happen anymore, or at least are significantly reduced by bringing these cases to light. With this project that we've initiated, we will be able to bring several of these cases to court, and not just it will make it costly for those who have already practiced those transactions. They will have to pay what's due to participants, but it will also disincentivize current shareholders from conducting transactions in a way that harms employees. If they do it, they will know that they will be sued sooner or later, and that they will have to pay whatever is due for participants. They will have to pay attorney fees. They will have to deal with reputational costs. Often these companies are built in smaller towns in the US or smaller cities in which everyone knows each other. So once it becomes known that the previous owners of company X screwed over the employees of a certain company, and that company represented, let's say, 20% of the workforce, there will be some quite substantial reputational damage. So that's also something that might discourage. And that's why I think that the work we're doing here has the potential of creating significant impact. That's why class actions were imagined in the first place, right? Not just to punish those that already violated ERISA, but also to prevent violations like that from ever happening again. So I think that what we're doing here is it's pretty interesting in that sense.
Yeah, no, very well said. I like to call it the Darrow deterrence. Definitely hoping to play a big part in the context of this cause of action, and appreciate you pointing that out. The one other piece of like narrative that I feel compelled to mention is just how sort of overtly these companies come out of the ESOPs, where they've just theoretically, pulled a fast one on these people who have helped them build their company. They actually come out and advertise how great of a job they've done by allowing the company to become employee owned. They don't disclose the fact that they essentially liquidated their employees' 401k savings plans, but it's just another example, excuse me for using the Yiddish, but it's just another example of the chutzpah that goes into these sort of egregious transactions. And I just wanted to add that in there because it's just so in your face. You look at a potential ESOP litigation, you look back and you realize that the company was actually bragging about this. Not, for the reasons that they're lining their pockets, which they're hiding from the public, but because they want to look like they're generous and altruistic as employers. But anyway, I just before we move to the question and answer segment, I'd like to ask you. So we have sort of the baseline, what I'll call the direct ESOP framework. You have employee stock ownership plan, you have employees participating in that plan, and you have the transfer of ownership from the employers, the board of directors, and otherwise to the employees. Are there any other ways in which these transactions play out, or is it always that straightforward kind of linear trajectory that I've just described?
No, absolutely. Sometimes there happens something we've been calling a reverse ESOP, which is essentially when after selling itself to employees, the company or a third party will repurchase those shares. That often happens when instead of the company being in a bad situation, they are actually growing. They just closed a government contract, they just opened new factories, or the price of whatever they do just increased. So what happens is that because employees don't really know what they have, they don't really have the tools to understand the value of the company that they are theoretically owners of. The fiduciaries and those third parties will get together and will take advantage of that situation and just buy the company from the ESOP for a lower price. Often they'll buy the company for the price that the internal evaluation says that the company is worth. However, that internal evaluation is also plagued by conflicts of interest because the fiduciaries or the shareholders, the board of directors of the company may have reached an understanding with the third party, as we've seen in some cases, to keep the evaluation down to make sure that they can buy it for a cheap price. Or they don't really incorporate into the evaluation new factors like that new government contract that they just closed that would significantly increase the price of the company. So that's another way of harming employees. And what's sadder is that in many of these instances, companies also celebrate. They also advertise participant X just made $500,000 because the company was sold. This is such a great story. It's such a great narrative. We're helping employees. But in actuality, employees were harmed. Instead of 500, they could have made $2 million and they will never even know. So there are different ways in which fiduciaries, trustees, and other parties come together in order to take advantage of the fragility of the ESOP structure, which is obviously not what the legislator had in mind when this was first designed. It's very sad, but as in other areas of ERISA, there's lots of creativity in how to breach the law in order to take advantage of it to benefit oneself.
Yeah, the chutzpah continues. Every time I ask you a new question, you continue to shock me with just how people are able to game the system at the employee's expense. And it just reinforces how important it is for the plaintiff's bar, for companies to be knowing that this is not okay, for the plaintiff's bar to be acting as a deterrent force against it. And of course, Darrow kind of underlying it all, bringing this injustice to light. So thank you for that additional context on what I think you've called the reverse ESOP fact pattern, if you will. So just moving into a couple of questions here that I've received from the audience before we go, Shai. The first one here says, when you, Shai, are evaluating a potential ESOP case through legal intelligence, what's the signal that most often changes your initial read on whether the case has real merit? Is that just simply the precipitous price drop? Is it something more than that? Is there, if everything else looks promising, is there that one red flag that really makes you want to look deeper? How do you think about that? Tell us about sort of your real-time engagement with these cases as you've, grown more comfortable with what this stuff looks like.
Yeah, absolutely. So that's actually a great question. Obviously, the first data point is the drop in the evaluations, but for it to be a violation, it has to be something that was known or should have been known to fiduciaries. If it's something that could not have been foreseen, then there was no malintent, meaning that fiduciaries didn't really know that the price was going down or that it had a chance to go down. I've seen a case in which there was a close to 90% price drop, but then when you
Wow.
investigate the company, you find out that they're an airline, one of their airplanes crashed, and obviously that leads to significant drops in price. You could maybe claim that they either knew or should have known that the airplane had a mechanical flaw X or Y, as we've seen in some of the Alaska airline cases, but that wasn't the case for that particular company. So whenever there's an element of uncertainty, whenever, let's say, a certain market, a company was selling something that's really not out there anymore, or something that was replaced by a new technology, you can't really say that that fiduciaries had any fault in that particular drop. If obviously if it was something that they could not have foreseen, if it was something that they were aware of, let's say that they're a car manufacturer and they know that Tesla is going to start selling cheaper electrical cars. If they know that and still they conduct the ESOP transaction at that moment, then it's a breach of fiduciary duty. But if they didn't, or if there was no way that they could have known, then not really. So that's really the element we always look for in addition to just the drop in price. You have to be able to claim that there was some sort of element of knowledge, that they knew what they were doing.
And it sounds like you need to really understand the context of the context in which the evaluation or the valuation, I should say, was made. I'm seeing another question here that kind of ties in, so I'm gonna kind of use my own words to kind of paraphrase here. Do you, we'd also do a lot of imprudent investment work where you try to find comparator funds to compare to the funds that were, improperly or imprudently included in a plan. In this context, do you ever try to find comparator companies, let's say, to give you sort of more factual context on whether or not a valuation was appropriate for the ESOP or more specifically the company that engaged in the ESOP transaction?
Yeah, absolutely. The example I gave on the airline was a company specific example. It was something that only happened to that particular company in the industry. However, there's also the market element. You have to analyze how different companies in that market performed over the same period. If there was something that affected the market as a whole, and that was the reason for which the investigated company's price dropped so significantly, then you can't really say again that something that was known or should have been known to fiduciaries. If the entire market went down because of Trump's new tariffs or because of the war in Iran or whatever reason, then it's something that we always control for. We always include comparisons to similar companies in order to show that the drop in price for the investigated company was indeed an outlier. We do statistical analysis to ensure that it was indeed something that cannot be attributed to market factors as a whole. And we have this approach essentially because often the private evaluations are confidential. You won't really have
Right.
access to them either until discovery or mediation or some advanced litigation stage. So you have to work with the information available. You have to be able to say with a fair degree of certainty that you know that price drop was known or should have been known to fiduciaries. We do try to make sure to control for that as much as possible to prevent that kind of defense.
Really interesting, and appreciate you giving us a little bit of insight into your workflow and your mentality, Shai. I do think, unfortunately, that's all we have time for today. To all our guests, thank you for listening. We hope you found it interesting. I know I did. I generally find it interesting when Shai talks. So thank you, Shai, again for taking the time.
Thank you.
If anyone listening is interested in working with us on an ESOP case or simply hearing more about what we do, please be in touch. I think we'll be able to provide, I'll tell you right now, you can reach us at contact@darrow.ai. I'm sure we'll have some more materials following up with you after this. But feel free to reach out to either one of us directly. I am jake.hirsch@darrow.ai. Shai, I assume you can give yours as well if
Yeah,
you.
so mine is shai.silverman@darrow.ai.
So that we'll include those in the materials. Thank you so much for spending a little bit of time with us, and have a great day.
Thank you. Bye.